Okay, so I got two, thank you, Mariah. Two things to do. One of them is real interesting and the other one is less interesting. Look, do you want to do the more interesting stuff first while you're awake, and then we can do the less interesting stuff, or do you want to do the nuts and bolts stuff first? So I want to work through this PowerPoint set, sources of law, and then, because this is such a long class, these are really two things I would normally do separately, and then I'm going to give you a crash course in 14th Amendment law, which is a lot more interesting. But on the other hand, do you think that, have you all looked at the sources of law PowerPoint set? Yes. Yeah, so maybe we should start there, because it'll give you sort of a grounding and more of a foundation in some of the nuts and bolts ways that this works. And so then after the break, when we talk about the 14th Amendment, I think it will make more sense. See what I'm saying? It will make more sense. So let's do that. Let's start with the PowerPoint. Now at this point, y'all, you have everything for the first exam. All of the things that are on PowerPoint, I think the last thing, that are on Blackboard, all the way through prior restraints, and then the blog post, how law is made, and I'm going to do another First Amendment blog post 2, and that's it. But you've got all the handout type material, chapter 1, 2, and 3, the PDFs that I sent y'all. That's it. So now it's just a matter for us to work our way through all of that material and take the exam when we're ready. Prepare the score, I appreciate it if you get there on time from now. Yes. So the very first thing that we have to do, that we have to get straight in our minds before we can talk in a more in-depth and substantive way about all this, we have to be clear about what kind of law we're talking about. The law is vast, it's enormous, nobody can know all of the law, that's why all of us specialize in one little area of the law. People have famously talked about it as the cathedral of the law. It's so big and ornate and complex. But we have to get a handle on at least knowing what the big structures are within this, and that's the whole point of knowing sources of law, or knowing what type of area of law we're talking about at any given time. So, 4 major areas of law, and we'll be talking a lot, obviously, about constitutional law, but those other areas of law are important as well. I need a little bit more board space, but I'm going to try to do it. I'm going to try to do it here, if I can. How about if I hold the screen like that? How about if I do it on both sides? I'll do it on both sides. So you have common law, constitutional law, statutory law, and administrative law. And now remember, we said in the last class that ours is a federalist system. What does federalism mean? Yes?
It's a relationship between the federal governments and the state governments.
Right. We don't have just one big, all-powerful federal government. We have 2 layers of government that are equally important, federal and state. And so the dividing line here is federal and state. And we have to reckon with both of those areas. Right? We can't just focus on federal law, we have to do both. Right? Common law, con law, statutory law, administrative law, operating on 2 different levels, federal on the top, state on the bottom. We've got to deal with both of them, and you'll see as we go through, there are certain areas of law that we're going to study where the state law is actually more important. Like when we talk about shield laws and journalist privilege and protecting confidential sources, the state level law is actually as important and in some cases more important. So the way this works is, remember that we have 3 co-equal branches of government. And one of the which is a hallmark of our system and which was new because we were going to treat them all equally. We weren't going to have a pyramid with one person or one part of government on top. We were going to make them co-equal. And part of the way that we make the branches co-equal is all of them make law. Everybody gets to be in the lawmaking business, all three branches of government. Now, so the way we can think of this is each branch gets an area of law. The judiciary owns these two. The legislative branch owns this type of law. And the executive branch owns that type of law. So see, everybody gets to get in on the lawmaking business. And it's another way that we create checks and balances. So if you have all three branches of government making law and participating in the lawmaking process, then no one, in theory, rises above the others. And also, if one branch does something the other branch doesn't like, it can, within its powers, as set out in the Constitution, try to do things to counteract what that other branch has done. Why do you think we call that last category administrative law?
It's passed by committees or administrations or...
By administrations. What type of administration? The presidential, because it belongs to the executive branch. You think of those agencies in Washington like the FDA, the EPA, the FTC, the SEC, the FEC, OSHA, NASA. You think of them as independent agencies, but they're not. They all live under the executive branch. The president and whoever's in the White House has a lot of control over those agencies. That's why after there's an election and a new president comes in, we talk about the agency holocaust, because they fire all of the old administration's people and they put their people in. So those agencies are very influenced by the president and how the president thinks things should go. And, well, I'll give you an example. So when Obama came into office, Obama is addicted to cigarettes, right? And cigarette addiction is very, very difficult. If any of you smoke, please stop now before it's too late, because you'll regret it the rest of your life. So anyway, so he had a lot of strong feelings about cigarette and that sort of thing, and then next thing you know, presto changeo, the regulatory agencies start coming up with new, tougher rules for the cigarette companies. Right? Anybody remember one change that they forced that the FDA, FTC forced on the cigarette companies in the last few years since Obama came in?
Aren't they required to tell you, like, all of the health problems, at least list all of the health problems that could occur?
That's been on cigarette packaging for decades, right? The Surgeon General's warning, and it has they have a series of different. Sometimes it says causes cancer, sometimes it says causes birth defects, sometimes it says all sorts of things. So those have been in place for decades, right?
Did they have to start like putting diagrams on the boxes?
Pictures.
Yeah, pictures.
And so the Obama administration, not the Obama administration, but the agencies under the direction of Obama promulgated a rule that went on the books in 2009 that said they had to put little pictures, gruesome pictures of like rotted lungs and things like that. They have it in France, they have it in Australia, so it's not unprecedented. Other countries have it. So they could make the argument that it wasn't a radical change. Other countries have it. Anyway, the tobacco companies fought that in court and they won, and so they don't have to do it. But there's an example of how some interest that the president has can find its way onto the agenda of these executive-controlled agencies. This is administrative law because it's associated with a administration, and they pass regulations, rules and regulations. And notice we have them both at the federal and state level. The regulatory agencies at the state level are quite important. Often it's a case where, let's use environmental regulation as an example. So the EPA has a lot of environmental rules. Then you go to a state like California, and their state agencies have environmental rules that are much tougher than the EPA rules. So the state version of these regulatory bodies actually are quite important. And you can have many variations from state to state. Then we go over here to, now we're in statutory law, and we have, of course, so we say, yes, we have this kind of law at both the federal and state level. Yes, yes. And we won't, when we're in this class, about the only regulatory stuff we're going to talk about is going to be up here in the federal level when we talk about the FTC. What's that?
Federal Trade Commission.
Which regulates what is of interest to us?
Imports and exports.
What do they have? What does the FTC regulate that is of interest to us in the communication school?
Information release.
Information? What kind of information? How many of you are PR advertising marketing leaders? This is you. So the FTC, along with the FDA, regulates advertising and marketing, PR. The FDA comes in when it involves labeling. So that's where we'll be in this course. Now, in this area of law, of course, yes, we have that statutory law at the federal level, and that's Congress passes. Laws that are passed by legislative bodies are called statutes, which is why this is called statutory law. And obviously, yes, we have it at the state level. In North Carolina, it's called the General Assembly. I don't know what it's called in your states. It varies. Right. Statutory law.
Why is there two different categories? Is it
Because it's federal on the top and state at the bottom. Right? It's just like we have two very different court systems. We have a federal court system and a state court system. When we're in this class, the area of statutory law that we'll talk about the most will be probably when we talk about testimonial privilege and protection of confidential sources, and we'll be talking a lot here. There is no federal shield law, which we'll talk about later, but North Carolina has a very good shield law that protects journalists. It's at NC Gen Stat section 8-53.11. And so that's where statutory law is going to come in. Mr. Lovering, you're very late. Now, here we have to start by asking ourselves, well, what's the difference between common law and constitutional law? So common law is the law that we inherited from England. So common law is many centuries old, developed in England. And so when we were colonists, we were living under English common law. Remember, we said that we had a lot of problems with those laws. We didn't like their laws. We wanted to create our own. So in those early years of America, a big part of what was going on in the legal sphere was trying to figure out which parts of English common law are we going to keep and which parts are we going to reject. And so one big change is that, remember we said for the first time, we actually wrote down a written constitution. And that's different from common law. How is it different? Well, what is common law? Is common law written down somewhere? Is there a book that says common law, rule 1, rule 2, rule 3, rule 4?
is it like a series of a couple documents, like 4 or 5 documents?
No, common law. You're thinking of
Like
the
the
Constitution of England.
Yeah, like the little C constitution.
Right. Exactly.
Isn't common law all done at the state level? It's not, constitutional law applies to the states, but the states are free to, come up with their own legislation.
No, you're just kind of blurring the line between three things. So let's sort out what you just said. So states can pass legislation. Yes, you're right. And that would be statutory law, the state legislature can pass legislation, and the federal
state has the ability to come up with their own legislation.
Yes, but notice you're talking about two different boxes, and so you're blurring this line. Constitutional law is different from statutory law. Statutory law is the law that legislatures pass, like the General Assembly. Constitutional law is law that comes from our constitutions, either the federal constitution or the state constitution, and then is interpreted by the courts. Right? And that's different from what the General Assembly does. The General Assembly doesn't interpret the Constitution. The courts, but notice we're under the judiciary, the courts interpret constitutions at either level. Now, there's a nub of truth in what you said, which I'll come back to in 1 second. What were you going to ask?
Oh, I don't know.
You don't remember? So, we know we have constitutional law at the federal level, obviously. It comes from the Constitution and Bill of Rights, and we already said that all the states pass constitutions too. Federal courts interpret the federal constitution, state courts interpret the state constitution. The federal courts can't trump the state courts in interpreting the state constitution, so this kind of constitutional law at the state level is also important. But here something happened with common law that is different at the federal and state level. Because we wrote down a constitution in 1787 and ratified it in 1789, to a large extent, constitutional law at the federal level replaced common law. And as a general matter, we say that there is no federal common law. There is no federal common law.
So basically, common law is not written down at all.
Common law is not written down like a code. Instead, common law is law that accrues over time through court cases. And to know what the common law says about any given subject, we have to go read the cases. So it's not written down like a rule book. Common law is law that accrues over time through cases. And so here's how it works. So let's say we've got man A, and man A is a farmer and he has a field of corn. Then we have man B. Man B is a rancher and he's got a cow. Or he's a dairy farmer and he's got a cow. And there's a fence in between their property. One night, the cow breaks through the fence and eats all the corn. And so man A then sues man B, and it becomes the case of the cow and corn. And so when he sues, then the first thing the court has to ask is, there is no rule book. There's not going to, you can't look up the rule of the cow and the corn because there is no rule. And so they have to go back and say, have we ever heard a case like this? Has a cow ever broken in and eaten the corn? No. There's no case like this. Well, then we're going to have to make a ruling on this. Afresh, a new ruling. And what is it called when they make a new ruling about something they've never heard before?
Principle?
Precedent. Precedent. Not president. Precedent. So they have created a precedent. We rule, therefore, that man B is liable for the damage that said cow did to said corn and must pay him actual damages in the amount of $30,000. So they have just created a precedent. And then what happens to that precedent over time? How is it used?
Standard.
As a kind of standard, it creates a baseline rule. So anytime another case comes to the court that involves a cow and corn, they're going to go back and they're going to look at that case. All right, so what if this happens? So now a year later, man A has the corn, man B has the cow, there's a fence in between. One night after doing his chores, man A's son leaves the gate open. And during the night, the cow goes through the gate and eats the corn. Man A now again sues man B. And the court says, well, we've got to go look at the cases. Have we ever had a case of the cow and the corn? Yes, we did. But wait a minute. Is this the same? Are the facts the same? Did the first case involve a gate? No. Did the first case involve a boy leaving the gate open? No. So what they're going to do is try to use that case as a starting point, use that precedent as a starting point, but distinguish, if the facts aren't quite the same, distinguish this new case from that one and come up with a ruling that still preserves that old precedent, right? They want to make only incremental changes in the law. And so then they're going to say, okay, we come up with a rule, we've reviewed the cases that we've heard so far, that case is inapposite, we must distinguish this case from it, because the facts aren't quite the same. And in this case, we find that man B is not liable, because the fault lies with the son of man A. Therefore, man B does not have to pay damages to man A. Yes?
So doesn't, I mean, yes, we have constitutional law, but doesn't the Supreme Court do a little bit of that when it goes back to look at?
This is why we don't need to have common law at the federal level, or it withered, what I should say is it withered away over time, because that's exactly the process that the Supreme Court uses when it decides Supreme Court constitutional cases. So we got as a starting point, instead of a case precedent like the case of the cow and the corn, we have the Constitution itself and the Bill of Rights itself setting the baseline rule. And then we have to study cases over time, because the Constitution and Bill of Rights, those words don't mean what they meant in 1789 and 1791. It changes over time through court cases, which is why we have to study the cases themselves. Now, on the other hand, at the state level, we still have very important common law. And I'll give an example in our sphere. Because remember that if it's a state level case, federal law doesn't apply in a state level case in a state court, for the most part. Generally speaking, I should say. So here's an example that is directly related to us. And who's from North Carolina? So in North Carolina, the courts have a very long history of being very protective of the media. It just happened that way over time. And so knowing our state's common law tradition of being very protective of the media through, in particular, libel law. Libel law, until 1964, was always a matter of state, was mostly a matter of state law, and then we'll see later on why that changed. But so knowing where you live is important. Knowing how the law works in each of your home states, or wherever you're working, is really important, because it's different in all 50 states. So who's from New York and New Jersey? Right, so New York and New Jersey have some of the strongest protections for the media in the country. Why do you think that's true? The courts in New Jersey and New York are very, very protective of the media. Why do you think that's true?
That's all the media stays.
Because there's so much media based there, and for so long, that both New York and New Jersey have very highly developed, very mature media law. California as well. Right? Another example that we'll see, another reason why state constitutional law, state common law is still important to this day. Well, let's say on the subject of protecting confidential sources. In North Carolina, for example, we have a statute that protects confidential sources. Our courts have also said that the North Carolina Constitution protects journalist sources, and our courts have said that as a matter of common law, that our journalists are protected, their confidential sources are protected. That's not true in every state. You could be working in the media in some other state, and you simply do not have the kinds of protections that we've got here in North Carolina. So I just use that as an illustration of why we can't only focus on federal constitutional law. We have to focus on all these different types of law, and we can't forget the state level, because it sometimes is very important. And you'll see this as we go with various topics that we talk about. You know, one week we might be talking a lot about in this sector here in constitutional constitutional law. Another week, we might be talking over here in this sector in regulatory law, right? And so we have to be cognizant of what area of law we're talking about. Another way to think about this, folks, is these 4 different areas of law, they act as avenues. Avenues for what? Avenues for redress. Avenues for us to work out our problems or settle a debate. So let's say, all right, well, let's go back to the cigarette example, since it's a real example and it just happened within the last few years. Okay, so you've got the anti-smoking people, and they want to try to get tougher on the cigarette companies. So they look at these 4 different avenues and think, how could we go about, which of these types of law would be the best avenue for us to try to pursue this, our goal? Well, knowing that the president was a struggling smoker who was trying to quit, and knowing that the president had a lot of interest in this topic, seemed like a good idea for the anti-smoking people to try to go the administrative route. And sure enough, the FTC and the FDA gets involved with advertising and stuff when it involves packaging and labeling. So automatically, the FDA is involved. And the FDA has long been involved with regulation of tobacco sales and tobacco marketing because of the health issue. So the time was right, and they got their tougher rules, and so the FDA passes a tough new rule. We're in the land of administrative law, saying that the cigarette companies must do this. All right, well now the cigarette companies are unhappy, and they look at those different avenues and think, which avenue could we use to try to get what we want, which is to strike down these, get rid of these rules. So which avenue are they going to try to use? Which one? But now remember, we started off with a federal regulation up here in this quadrant. So which avenue would they go for?
Statutory.
They would try to get Congress to pass some law saying what? Let me just use your imagination. If they chose this route, here's the reason why that's a good answer. So often, when people have a problem or something that they want to try to get the law to remedy, this is the best route. Statutory law is the first choice. It's the first place to go. Why do you think that's true? If we've got a problem that we want the government to do something about using the law, why is the statutory route the first route that we try?
Because it's Congress, so it's the voice of the people, essentially.
That's right. We think about the legislative branch, whether it's Congress at the federal level or the General Assembly, is closest to the people. They're the ones who are the most available to us. It's like, what if I wanted to get something done, and I look at these avenues and I decide, oh, I'm going to go to the executive branch, right? Well, that wouldn't be very likely. Hello, operator, could you get me the White House? I'm not going to be able to get through, whereas our representatives are supposed to be easy. You go to congress.gov, and you can look up the phone number, email address, and mailing address of your congressperson, and they will answer you. I mean, I've exchanged emails many times with my congressperson. And so they're more available to us. And they're supposed to be, by design, they're supposed to be more in touch with us. So that's often the first way that people go, is to try to go the statutory route, get Congress to do something. In this case, though, Mr. Walston, I don't think that Congress could not pass a law that trumps this regulatory rule in a way that another branch of government could do that. So which avenue? If the tobacco companies are upset about a regulation passed over in this route,
They could sue,
of course they're going to sue.
so it would be
And
judicial.
so here we are up here, and so what avenue? Look at the chart, what avenue? Constitutional law. They're going to use this constitutional avenue, and they're going to sue which is what they did, in federal court to get that regulation overturned. And they won. And they won. And that's particularly a really good illustration for us to use because this is exactly because it's a First Amendment case. Why is the cigarette labeling on the package a First Amendment case?
Because it's a form of speech.
It's a form of speech. It's a form of speech. Yeah, but the government didn't prevent them from saying anything. Did it?
You can't force someone to say something also.
It's because you can't force someone to say something. The First Amendment protects your right to speak, but the First Amendment also protects your right not to speak. It's called compelled speech. Compelled speech is a no-no under the First Amendment. And so that's why they sued. Right? So it becomes this compelled speech First Amendment case. They sued saying that this regulation violates their First Amendment rights. And then the court runs the four-part Central Hudson test and determines, yes, this agency overstepped the bounds. And we'll talk about the Central Hudson test later when we talk about commercial speech. And they won. And so that's how this drama plays out. That's how these avenues of law can be avenues to facilitate a national dialogue or a debate, to help settle problems or settle arguments, to help redress some grievance. Right? So let's keep that in mind about how these different areas of law are dynamic and they can and these discussions can play out, inside one of these avenues, but there can be interplay between these different types of law. Do you see that? Any questions on that? Any other examples? Another good one that's playing out right now that somebody mentioned in the other class is the fight over GMO labeling on food. Right? You all know what that is? Genetically modified organism. And so there are a lot of people who want the companies to have to label the food to say that it does contain GMO material. And so that fight, that debate has been playing out in two different realms. We've got the administration and these administrative agencies under pressure to pass tough rules. Then we also have people trying to lobby in Congress to get Congress to pass a rule. Right? You see these different parties looking at these avenues and thinking, so now we have two different groups here, the people who want the GMO labeling and the food companies who don't want it, and they're both lobbying Congress, and we get the debate going on in this area of law. And then we have the regulatory agencies over here promulgating new rules, and the process is not undemocratic. They can't just announce a rule. They have to send out a notice of proposed rulemaking and let everybody know, and then they have to let the public give input, right? And they have to have a 90-day period, 90-day window for everybody to log in or lodge their opinions about it before they make a rule. So we've got debate about GMO food labeling right this moment playing out in two different areas of law. And we'll see who's in favor of GMO food labeling. I'm just curious. Who is even following this issue? Who cares about this issue? Only two people in the class care about this issue. Don't you care about GMO food labeling?
I do, I just don't know what it is. I care a lot.
That's good to be honest.
We deserve the biggest fruit science can create.
What's that?
We deserve the biggest fruit that science can create. Like the real big strawberries that they genetically modified and make them fancy.
They said they glow in the dark. That's a little problem. Yeah. So the issue is food that has been genetically modified, and a lot of scientists believe that those foods, when they have been genetically modified, it creates, for example, cancer-causing chemicals in the food, that it changes the food and makes the food less healthy and sometimes even harmful. And so the advocates are, of course, ultimately the advocates would like there not to be any GMO food at all, but all they're asking as a compromise is, well then at least give us the choice. Like, let us know on this package, this one does contain it, and on this one it doesn't contain it, so that as a consumer I can make the choice that I want to make.
And most food companies are doing that now anyway.
Some are doing it voluntarily, but they don't have to do it, right? So that's just, I think both the tobacco thing and the GMO food thing are good examples of how these different areas of law can interact. It's like we talk through the law a lot. We use the law to facilitate a national dialogue about some topic. Congress most immediately comes to mind as the arena where that discussion takes place, but it also takes place in these other areas of law as well. And so, again, for note-taking purposes, we said it's court-created law that accrues over time. So we said that when the court created the precedent of the case in the cow and the corn, when cases come later that involve cows and corn, they're going to try to preserve that original decision. And that's because of the principle of stare decisis. It's the kind of bedrock philosophical principle that as often as they can, the court is going to stand by the earlier decision. And if the facts of the later case don't exactly match that first one, they're going to try to make as little change to the law as possible. We call this incrementalism. Judges prefer incrementalism. They don't like to make big, sweeping changes to the law all at once. For the most part, but we will see some examples where they have done just that. But for the most part, judges like to be thought of as showing judicial restraint. Judicial restraint. And they do that through incrementalism, just making small changes to the law as necessary over time. And so they want to, as often as possible, accept the precedent. And if not, if they can't do that, then they want to just modify it incrementally. And then as a last resort, they will overrule an earlier precedent. And this works the same in common law and constitutional law. Because constitutional law plays out like common law. And so again, some note-taking, some definition, glossary term.
Is this on Blackboard?
Yeah, it's all on, everything's on Blackboard. All that's on Blackboard. So just a note here, you have to put aside political labels here for a second and think of these terms just in the way that they play out in the law. So a liberal judge, and I don't mean that liberal like, in the political sense. Liberal meaning they feel free to do things, as opposed to a conservative approach, which would be try to keep things the same. Is more likely to be a judicial activist. Judicial activism, now it doesn't mean conservative or liberal in the political sense. A judge from either political persuasion could be a judicial activist. Right? We're not talking in the political sense. So judicial activism is when a court uses its power of judicial review to overturn or strike down actions or laws of other areas or other departments of the government. What's judicial review?
The ability to look at, was it previous cases?
The ability of the court to declare something constitutional or non-constitutional.
Right, and the key is it's that was done by some other area of government, right? It's not going back and looking at their own cases. It's when it's looking at the actions and activities of other branches of government, right? The most common example would be Congress passes a law, and then using judicial review, the court reviews that law and determines whether it's constitutional or not, right? And what case gave us judicial review? Marbury v. Madison. What year?
1803.
1803. Who wrote the decision?
John Marshall.
John Marshall. Right. So you see that principle, that's how it works and plays out today. Judicial activism is when the court uses its power of judicial review to deem some action or law created by another area of government, another department of government, as constitutional or unconstitutional. or strike that, I mean, as unconstitutional. It's when they strike something down, or they rule that it's unconstitutional. That's activism, is when they use their power of judicial review in an aggressive sort of way, an assertive sort of way. And then judicial restraint is simply the opposite. It's when, so here's the paradigmatic example. Congress passes a law, and the court shows a lot of deference to Congress and says, well, you know, they studied this a lot, and this is a matter of public policy that they think is important, and so we will let that law stand. Right? So they show a lot of deference to Congress. It would have played out in the tobacco realm case, for example, if that federal court that heard that case, in the decision, they could have, instead of what they did, which was struck it down as unconstitutional, another way they could have decided that case was they could have reviewed the long history of tobacco regulation, and they could have said that the FDA has shown that it has the institutional competence to set public policy, and so we will defer to the FDA's expertise. That would have been judicial restraint. But instead, in the case, what we saw was judicial activism, which was the court using its power of judicial review to strike down that regulation that's unconstitutional. See that? This very interesting interview with Ruth Bader Ginsburg in the New York Times last week, in which she said provocatively that the Roberts Court is the most activist court in history, or recent history.
Well, you're more active than Warren.
What's that?
I said you're more active than Earl Warren.
She said recent history,
Oh,
because that's going back to the 60s. So that means, by definition then, you know, just by putting the definitions against what she said, her quote, then you know that means, even though you don't know the cases and haven't been following the court, that from her statement, what she's saying is that the Roberts Court has struck down a lot of things as unconstitutional. Right? Remember, let's use as our example the Citizens United case. You should all Google that case at some point and look it up. It's a very interesting case. It was from only a few years ago, and in that case, the Roberts Court basically erased about 100 years worth of campaign finance law. And that's a very activist use of judicial review. And again, just some note-taking about what judicial restraint is. And we said this is statutory law is written by legislative bodies. So we're in this realm right here. And just to give an examples of things we'll talk about copyright law. Why is copyright law in this realm? I'm in the statutory realm at the federal level. Why is copyright law up here? Because the Constitution says it belongs here. The Constitution specifically says in Article 1, Section 8, that Congress shall have the authority to oversee copyright law. So then that tells us, we can put it together and say, oh, copyright law is statutory law. Congress writes copyright law, and then the courts interpret it. Advertising will be over here in this sector because of the FTC and FDA. Broadcasting will be still over here in the regulatory realm because of the FCC. What's the FCC?
The Federal Communications
Federal Communications Commission. And when we deal with FOIA, we'll be back over the statutory law. That's the Freedom of Information Act. That's how we force the government to give us documents. Right? You make a FOIA request. You say, you, Obama administration, give us all of those emails about the NSA spying program. Right? Have y'all been following those revelations? They just keep coming every day. Like in the last 2 weeks, there's a story about the NSA, the National Security Agency, used wiretapping to spy on all of the officials at the UN. And then another story comes out saying that they use it to spy on all these officials in the EU, the European Union. Right? Then, and then the latest one, this just caught my eye the other day. They used it to spy on judges on the Supreme Court. Right? How about that? So anyway, we'll deal with that. So you would use FOIA if you were trying to force the government to give you documents. Then we'll be talking a lot, as I said, when we talk about, at the state level, when we talk about libel, State common law is going to be important there. When we talk about shield laws, state statutory law will be very important. We talk about access laws. We'll talk a lot about Section 132 Public Records Law and Section 141 Open Meeting Law in North Carolina. And those are different from state to state. So as a professional communicator, you'll need to be aware of the laws wherever you're working. And then just to give an example, we're not going to talk much about this. There actually is another layer down here, and that is you can have statutory law also at the local level. Also at the local level. Obviously, you can't have constitutional law at the local level, but you can have, and you can have some administrative law too at the local level. Right? So, who's been to a party with a cop show up? Come on, you've been. All right. So, why'd the cop show up? Because of noise. And it's because there is a noise ordinance. So let's use that as our example. A noise ordinance is an example of statutory law at the local level because it would have been passed by the city of High Point. So rules like that the High Point City Council made, those are also statutes. And then we talk a lot about constitutional law. Here's the supremacy clause from the Constitution, saying that the Constitution and the Bill of Rights, of course, shall be the supreme law of the land. Judges in every state shall be bound thereby. And anything in the Constitution or laws of any state to the contrary notwithstanding. So federal constitutional law is the supreme law of the land, and it's the trump card. Trumps other types of law. And we talked about this in our discussion. We said in the seven articles, the first three are the most important. Article 1 sets out the powers and authorities of legislative branch. Article 2, executive. Article 3, judiciary. That's interesting. Why do you think? Because in politics today, we've got it so backwards, right? Politics today, it's like we've turned it into kind of this celebrity cult of personality, right? The president is the most important, but that's not how the Founding Fathers saw it, right? That's why when you look at the construction of the Constitution, Article 1 ain't about, they don't start with the president. It ain't about the president. The longest and most detailed part of the Constitution is about Congress. Right? They don't want a pyramid with an all-powerful person on top. They wanted a level playing field. And we said that the first 10 amendments are the Bill of Rights. We've got 27 amendments so far. Just some note-taking about the functions of the Constitution, which we've already talked about. There's the First Amendment, our beautiful First Amendment, which you will all know word for word very shortly. Just again, some language. Just showing you some language from the Constitution, the Copyright Clause. And this is an enumerated power. An enumerated power. They actually specifically said, here's one power that Congress has. And we talked about judicial review. And we talked about the regulatory agencies, and these are the three that we'll be looking at. We'll talk for like 1 second about the Copyright Office. The FCC, FTC, and FDA are the ones that we'll talk about. So just to make the point here, while we have to try to get clear in our minds, which is when I'm offering this visualization, what types of law we're talking about, what level are we talking about, federal or state? Because look, you got to remember, we have 52 judiciary systems, right? We've got federal in all the states, and District of Columbia. What's the difference between a criminal case and a civil case?
In the case of a criminal case, you have violated a particular law. So, you can't kill somebody. that's a law. And if you kill somebody, you violated the law. So then it's you versus the state.
That's right. It's you versus the state. So if you kill someone, you have violated the penal code in North Carolina. And so it's Walston v. the people of North Carolina. And then in a civil case, so what's different in a civil case?
Isn't that brought by like a private party?
It's private parties, it's people. One of the parties could be a corporation or a group, but yes, it's just parties. It's not against the state. It's not you against the state. It's you against somebody else, right, in a civil case. What's another key difference between a criminal case and a civil case? What's the end result? What can be the end result of a criminal case? The government can kill you or put you in jail. Right? You don't get killed at the end of a civil case. But you can get killed at the end of a criminal case. You can be put to death. So what's the end? What can be the end result of a civil case? Money. You have to pay somebody damages. If they win their case, you owe them money. Right? National Enquirer runs an article saying that Tom Cruise is gay. Tom Cruise sues. What does he sue for? He sues for libel. And this is in California. And he wins. He won something like $5 million. And those are called damages. So he won damage. They had to pay him $5 million in damages. And we talked about the, I'm going to have to erase this so I can write something up here. The difference between, what's the difference between a trial court and an appellate court or an appeals court?
A trial court is defined if someone has actually broken law or civilly figure out whether they get damages or not. And an appellate is to figure out whether a trial court or a lower court has messed up on a law or a procedure.
Exactly. So the first example that you gave, the first type of court is focused on facts. The lower level court where your case first starts, and in the federal system, this is a district court, is a trier of facts. And so a way to remember that is this. District court is what y'all all know from all your favorite crime shows. Because that's where you got the courtroom and you got the jury and all of that stuff. And it only happens at that level. A trier of fact, it has a jury, and they've got to figure out the facts of your case. Then let's say, so then you lose and you were convicted of murder. And so then you appeal it to the appeals court. And they are not, now sometimes they will go back and look at the facts, but they're not a trier of fact. When you get to this level, it's a trier of law. It's a matter of law that they're interested in. And what they're doing is these are glasses. They're looking down at the lower court to see whether the lower court did its job correctly, whether they applied the law correctly.
What does that say to the left of the middle block?
Down here, ... District court is a trier of facts, and when it gets to the appeals court, it's just a matter of law. They're only concerned with law, and that's the same thing when you get up to the Supreme Court level. Rarely are you going to make it up here. If you get convicted of murder here, and of course your attorney is automatically going to appeal the case, and it goes to the Court of Appeals. If the Court of Appeals looks down at the district court and says they didn't make any mistakes, everything was fine, 99% of the time it's over. The Supreme Court is only going to take your case if it looks down at these other two courts and finds some serious error in what they have done. Or if the court wants to take the case because it deals with some legal issue that they want to make some statement about. Maybe they want to change the law in a certain way. Only about the court We just talked about that, so some note taking. Free note taking for you guys, I should start showing.
Yeah.
And so again, we did this, a lot of detail that we don't really need to. The appeals court decisions, anybody who does legal scholarship, you'll find that you're dealing a lot with these courts, because they take many more cases than the Supreme Court. And these cases are the precedents that they set are very important. Just a lot of these, I was going to drink wine. Okay, so I just want to say this. All you need to, this is just a glossary term. A diversity case is when you've got, it's a civil case where you've got two people and they're from different states. And so diversity cases automatically go to federal court. Because like, if you're from California and you're from New York and you're in a suit together, then it would be, it wouldn't be fair if you had to have your case decided under his state's law or vice versa. And so it goes to federal court, that's all. A diversity case goes to federal court.
So then that just means that neither state's laws apply.
Neither state's law can have undue influence over the case. Because remember I said state law is very different from state to state. And it could give one or the other some sort of advantage. Just scratch this. I mean, I told you what I want you to know about how courts work. I mean, in the state courts, it's essentially the same. Sometimes these names are a little bit different. Like in Massachusetts, for instance, their Supreme Court isn't called the Supreme Court. It's called something else. Anyone from Massachusetts? Yeah, what's your Supreme Court called? It's weird. It's like the appeals court is called the Supreme Court, and then the Supreme Court is called something else. I can't remember. It's odd. But anyway, it's basically the same as the state, and I don't want you to know all of these details. Okay. Let's just stop there. I'm getting bored with it. Let's take our break. And so just don't worry, like wherever we stopped off, that's it. There's a lot of detail in there that I don't want you to worry about. So let's take a break, a 5-minute break, and try to freshen up because the next section is interesting. Josh, if you want to pause and take, good.